Suspension of Senator Natasha Akpoti-Uduaghan is unconstitutional, excessive, and a violation of the senator's constituents' rights to representation. Akpoti-Uduaghan, representing Kogi Central Senatorial District, was suspended by the Senate in May 2025 after she submitted a petition alleging that she had been sexually harassed by President of the Senate, Senator Godswill Akpabio. After dismissing her petition on procedural grounds, the Senate's Ethics Committee recommended Uduaghan's suspension, saying she had brought public opprobrium to the upper chamber of the National Assembly and stressed that the decision was not because of her allegations against Akpabio. The Senate President has approached the Court of Appeal to challenge the Federal High Court judgment, arguing that the Federal High Court lacks jurisdiction to entertain the case. Let's talk now to Ibrahim Wali. We're joined by him over the line, a private attorney with I.U Wali Law Firm, who's been monitoring this case and studying the processes and final order in detail. Ibrahim, thank you for joining us. How are you on this Friday?
I'm very fine, thank you. Thank you for having me. I hope I'm audible enough.
Yes, you are, and thanks for making time for us. What do you make of the Senate's reaction to the judgment, insisting that the court gave no binding order mandating Natasha Akpoti-Uduaghan be reinstated?
Well, been seized with the disposition of the Senate even before this matter began, and obviously throughout the proceedings and everything that led to the proceedings. I anticipated this type of defiance even from the day that the court gave the order. I anticipated that the Senate would try. I believe that what we have now is just the order, not the complete ruling of the court. And if you look at the preamble to the order, it is clear that it is meant to be binding because it begins with the phrase, it is hereby ordered. It is hereby ordered. And then the court now went on to give about 12 distinct orders. Now, I have to say, I have to concede that the court could have been a lot more clear. It could have been a lot more final and a lot more direct in its wordings, and the court erred in that regard. But all the same, you know, in the spirit of constitutionalism and the pristine understanding and following of the rule of law, and especially if you respect the court, you know, looking at the constitutional provisions that mandates, you know, even the decisions of the court, opinions, judgments, and even recommendations, you know, as binding. And these are issues that the Supreme Court has since settled, you know, in terms of how to interpret court judgments. But if you look at the judgment, you'd see that, you know, the language differs in two ways. You know, and when the court was speaking about the contempt of the senator who was the applicant, Senator Natasha herself, the court made it clear that she should pay, or rather she will pay, or she must pay 5 million naira fine for her contempt, even though the court before then mentioned that, you know, it's only going to focus on the originating summons, the preliminary objections, and the motion or notice, that is the interlocutory application. But the court went ahead to give a decision on the application of the respondents that she was in contempt of court. But I think it will interest you to know that the court had earlier officially on a recent order, or rather before the matter was transferred to this particular court, the previous court had earlier held the Senate in contempt of its own direct order, because it had earlier given an order even before the suspension for all actions regarding the Senate committee, you know, based on the subject matter should stop. But the Senate went ahead and suspended all the same, regardless of the order. So the applicants made an application for contempt, but the court didn't entertain the application for contempt, even though the abuse was more direct compared to what the senator did. But all the same, you know, the Constitution is clear as to the weight of the decisions of the court, and this is the order of the court. This is not the complete ruling where you can make the argument that maybe it's an obiter dictum, that is, you know, maybe it's a suggestion of the court, maybe it's opinionated. It's supposed to be an order, and it reads order 1, 2, 3, 4, 5, and it begins with it is hereby ordered. But indeed, the language of the court was that the Senate has the power and the Senate should recall Senator Natasha, it would have been a lot more clearer, a lot more firmer if the court had said that the Senate must, or rather, the senator shall resume her duties immediately. But it is important to know that preceding all those orders, the court held that indeed the suspension was excessive, and it was unconstitutional because it disallowed her to perform her constitutional functions as a parliamentarian. So it is known to law, and I think even year one law students know that immediately a decision is held to be unconstitutional and it is void ab initio. You don't need the court to come and expressly say that, okay, the decision is void. It helps if the court goes ahead to do that, but you do not need it. So the Senate is just being clever by half, and obviously, the court allowed it a little bit of opening, at least something that allows you to file a notice of appeal. And naturally, when you file a notice of appeal, then there's that presumed stay of execution of the judgment, and obviously that this is the position of the Senate, that they have an appeal and the judgment is merely advisory, and we need the Court of Appeal to come in and interpret it and make it clearer one way or the other. And but I feel like, if they were going to respect the rule of law and respect the judiciary and, be statesmen as we expect them to be, it wouldn't have been an issue. They would have understood that the disposition of the court is that their action was excessive and unconstitutional, and therefore it ought to be reversed. So that is my own understanding of it.
Yeah. What procedure then was Senator Natasha Akpoti-Uduaghan supposed to follow when it comes to these accusations of sexual harassment? And as you see it, where did she default?
Well, first of all, this particular judgment stems from an application, via an interpreting the action of the Senate, changing her seat, refusing her to speak in the Senate, directing her to the Ethics Committee, and the subsequent suspension. It has nothing to do with her own allegations or her own petitions against the Senate President, the petitions against sexual harassment. That has to do with her role as a senator and the change in her seat, and the purported suspension and the trials itself. But I think that she has a separate suit against the senator, that is based on the sexual allegation. I'm sure she also has a petition. She also had a petition against him at the Senate that was based on sexual allegation, abuse of power, and similar claims. But obviously, the Senate committee, used some sort of technicalities, including the fact that the matter is in court, to step that aside, and that has not been resolved. So we've not had any resolution whatsoever, either by the Senate or the courts, regarding the sexual allegations itself. But obviously, the sexual allegations can only be proven in court, and I'm sure she's in court. That matter is ongoing, so it's unconnected to the judgment that was delivered last week. So as far as the allegation is concerned, it's still yet to be decided. I think that the contempt, the particular contempt that the court held in breach of, it has to do with a post that she put out on social media. I think it was a metaphorical post. I think where she was sort of apologizing to the Senate and the Senate President, but it wasn't really an apology. It was just it was veiled some sort of I wouldn't say condescension, because I didn't think it was condescending, but then obviously we've not read the complete ruling, so we don't even know what the reasoning of the court is. And it's unfortunate because it's been 1 week since the judgment is out and we're yet to get the complete ruling so that we can follow the reasoning, the thought of the court, and maybe the judgment would make more sense to us. So yes, that's the position we found ourselves in.
So the Senate President argues that the federal court lacks jurisdiction on the matter, as you touched on. Does the Federal High Court lack jurisdiction to entertain this case?
To be frank, this argument has it predates even this case, but the Federal High Court, even in this same order, held that the preliminary objection where its jurisdiction has been challenged, it succeeds in part and fails in part in their argument, and I think that this is her reason, and it succeeds, where it has to do with, constitutional infringement of her rights, rights of representation, and so forth. But the court also, I want to believe, claims that, she doesn't have the right to challenge the internal democracy or the internal proceeding of the parliament, right? So the argument of the Senate is that when it comes to the internal proceedings of the Senate or of the National Assembly, then the court has no jurisdiction because, it feeds into the doctrine of the democracy, separation of power. But I disagree with that. I think that as long as a decision can be found to have infringed the Constitution and the decision is not backed by an express law, and I think that the court indeed has the power, has the right to come in and try to rectify that decision. So I believe that the Court of Appeal is going to make a more resolute decision, on either way, because currently, if you look at our, judicial archives, you would find that it's leaning more towards the court not having jurisdiction, but we don't believe that is a sound jurisprudence. We believe that as long as you can establish that breach against the Constitution or against the law that gives you a certain power, certain privileges, or certain rights, and the court can come in and protect it. Whether there's an actual breach or the breach is in anticipation, then the court should have the right, the power rather, to come in and protect it. But as our jurisprudence is currently, there is no definite position, and in fact, it leans towards the court not having jurisdiction. When you look at previous matters involving senators and the National Assembly generally, or the Senate,
where to from here? What's the next avenue to explore then? Should the Senate President in the Court of Appeal not get a favorable outcome? And also on the side of Senator Akpoti-Uduaghan, where does she go from here?
Yeah, both parties have, I'm sure both parties have already filed their appeals at the Court of Appeal, and I'm sure that in a little time, their briefs are going to be sent in. But immediately they are done, then they still have, the right to go to the Supreme Court. And we hope that the Supreme Court, because I believe that they would most likely go to the Supreme Court, because most matters in Nigeria generally, when parties are aggrieved, especially in matters of this nature, it almost always ends up at the Supreme Court. Sometimes it doesn't even end up there. They file another action with, really constructed claims such that, they try to distinguish it with the... But I'm very sure that, if either party does not get a favorable judgment at the Court of Appeal, then they are going to go to the Supreme Court, and I hope that the Supreme Court is going to have a final say. But the problem here is that... all right, no problem.
Let's leave it there for now. Ibrahim, thanks for your time again.
No problem. It's a pleasure. Thank you so much for having me.
Thanks. Ibrahim Wali.